Premises liability, trespassing law. The legal obligations that a property owner owes to other persons within the boundaries of the owner's property are protected under premises liability. You should familiarize yourself with what property may fall under your premises. You could be held liable for accidents that occur on these premises. Invitations to the property are granted to visitors from the property owners, family, managers, or staff. There are 3 common types of visitors. Invitees. Any individual invited onto a property in order to conduct business with the property owner, manager, and/or staff. Any individual invited onto a property for social purposes. Trespassers. Any individual who enters the domain or private property without a prior invitation from the property owner, manager, and/or staff. Trespassers do not have a claim against property owners for any injuries that occur while they are trespassing on the property. Visitors must be given consent to enter the property, otherwise they are considered trespassers. Visitors can be invited onto a property through one or more of the following types of invitations: written, spoken, or implied. Written is any documented form of invitation consenting to a visitor's presence on the property. Spoken is word-of-mouth consent granted in a conversation between the property owner, manager, or staff and the visitor. Implied is consent that is implied due to a long-standing relationship, past invitations, or certain circumstances. This type of invitation is more subjective and harder to prove than others. Examples include family members visiting each other's homes, patients visiting their physicians, or neighbors walking on other neighbors' property. Once an invitation has been accepted, both the property owner and the visitor must meet expectations to ensure the visitor's safety. Otherwise, a premises liability lawyer may be necessary to file a claim. Property owners, including managers and staff, must meet 2 expectations to ensure the visitor's safety, including making reasonable efforts to protect the visitors from likely dangers. If a property owner does not make reasonable efforts to protect the visitors from likely danger, or there is evidence that the property owner did not consider how to avoid injury to visitors, the property owner can be held liable for a visitor's injury. Consider foreseeable harms. Not all incidences are predictable, but the property owner is expected to consider any and all plausible future incidences and do everything in their power to avoid these incidences from occurring. If you or a loved one has suffered an injury on another party's premises due to the property owner's negligence, contact TorHoerman Law for a free, no-obligation case consultation with an experienced premises liability lawyer.